As a criminal defense attorney who's handled a wide variety of domestic violence or related crimes in the Seattle region and the outlying region of the Puget Sound area, and in some cases on the east side, I have some thoughts on domestic violence crimes as it relates to investigations and allegations of child abuse, and in particular child discipline abuse cases. The state of Washington, people in the state of Washington, and frankly people in the United States are all divided around the topic of child discipline. Some people believe you should never touch a child. Some people think it's appropriate to discipline them how they were disciplined when they were raised. What's important to know is that in Washington, you are allowed to discipline your child as long as doing so is reasonable and moderate, and it's for purposes of restraining and correcting the child. You can also delegate that ability to guardians and to teachers, but that's another discussion. The statute that defines the law that I just referenced is RCW 9A.16.100. And it further goes into defining what is reasonable and moderate. And as typical with the law, it doesn't give you a straight definition. It tells you what you can't do. What you can't do is you can't strike a child with a closed fist. You can't burn a child, cut a child, throw a child, kick a child. You can't shake a child under the age of 3. You can't interfere with their breathing. You can't threaten them with deadly weapons. And you can't do any other act that's likely to cause, and which it in fact does cause, bodily harm greater than transient pain or minor temporary marks. So it's interesting. Again, you can't do anything that causes bodily harm greater than transient pain or temporary marks. That means open hand spanking with a reasonable amount of force on the rear end of a child is not child abuse. It's authorized by the statute. It's also important to know, however, that the age of the child, the size of the child, the condition of the child, the location of the injury all affects whether your behavior will be considered reasonable and moderate. So spanking a newborn that's a month old is completely different than spanking a 13-year-old boy. And so the definition of what is child abuse is somewhat open to interpretation. And I think what's important for anybody to realize is if they're under the investigation of child abuse, that they remain calm, they listen to what the concerns are of the investigating agency that's involved, that they tell them that they are interested in making sure the child is safe, that their friends and their families do what they can not to take the accusation personal and lash out at the investigating agencies, but assure them that they will follow whatever requirements they need to make sure that that child is safe. It's in these sorts of circumstances that are this personal that, although it's self-serving, we highly recommend you contact counsel, an independent third party who is reasonable, listens, understands what's going on, is experienced with these kinds of accusations, is almost necessary to guide a family through these events, because it is the worst time to lash out at an investigating agency over accusations of child abuse. It is the worst time to lose your temper. It is the worst time to express your frustration in a negative way. What you want any state agency to know is that you too also think that it's important that the child remain safe, and that during the pendency of the investigation you will do whatever they ask to make sure that that child is kept safe. State agencies have authority under emergency orders to take custody of children. And even when there's a misunderstanding and they overstep their boundaries, clients don't get their children back until I get in front of a judge, which could be 5 days later or whatever. So demonstrating extreme compliance with the investigation process, remaining calm and listening, and realizing that you don't have any obligation to give a statement, and more importantly, you shouldn't give a statement because you don't know what their point of view is. You don't know what the biases are of the people that are asking you the questions. You don't know whether they're going to write down your answers properly. You don't know if your answers are going to be taken out of context. And of course, you don't know if your answers are criminal.